back with another Q&A edition of GovCon Intelligence. First, I wanted to go through a couple of documents that came out over the past few weeks that are important for small business contractors. So we'll talk about the FAR Companion Guide and then the Department of Transportation's frequently asked questions on the Disadvantaged Business Enterprise Program, the DBE program. The FAR Companion Guide came out last week in version 2.0. And so now we see the companion guide for Part 19. There's a lot of material there for Part 19. But the most interesting part of it that I saw was actually outside of Part 19. It was in Part 8, which is the required use section of the FAR, and then therefore the companion guide. The companion guide's scheduled or organized with the same numbers as the FAR uses. And Part 8 of the companion guide told us the meaning of the mysterious term required use. If you remember, about a month ago, or now 2 months ago, the FAR changed the requirement to use best-in-class contracts in the overhauled Part 8 to the term required use, but at the time we didn't know what required use meant. And now we get a clue in FAR Companion Guide 8.104 as to what required use is. And it says that, first of all, there aren't any required use contracts yet. So we don't necessarily know specific contracts that will be required under this required use, but it will be a new tier under the category management program. If you're familiar with category management, currently it has 3 tiers, and there's also a tier 0, but 0, 1, 2, and 3. And required use will be a tier on top of the existing structure. It will be tier 4 in the category management program, tier 4 in what they call spend under management. And it will be separate from best in class. So there are a few best in class contracts right now. Oasis Plus is one of them. 8A Stars is another one. This will be a whole nother tier. And there may be some of those best-in-class contracts that maybe get elevated to tier 4, or it may just be new contracts, new requirements that contracting officials that are organizing contracts will try to meet in order to get to this required use level. This is all to say that required use is an additional element of the existing category management program. It'll still fit in that framework of 10 categories organized by PSCs. And if you're working within those PSCs, it's worth it to take a look at the structure of the category management program to see what contracts to target and where those might fit into your business plans. In addition, with the FAR Companion Guide version 2.0, the FAR drafters also published a category management buying guide that's online at acquisition.gov so that you can see what contracts have been designated as tier 3, tier 2 within the category management program. Eventually, when contracts start being designated as required use, that designation will go into the category management buying guide as well. That was a interesting element of the FAR Companion Guide that came out in version 2.0 last week. Now into FAR Part 19. This was the first version of the FAR Companion Guide that went into small business, which is FAR Part 19. And consistent with what the FAR published in the FAR overhaul, this companion guide makes clear that the rule of 2, which is the set-aside rule, does not apply to orders. The rule of 2 is the rule that tells agencies you must set aside that award for small businesses if there are 2 or more small businesses that could perform that contract at a fair market price. The FAR overhaul used the word contract, which was just mentioned. It uses the word contract in defining the rule of 2. That word used to be acquisitions under the current FAR, the old FAR, and now it's switched to contracts. And the FAR Companion Guide explains why is it that they switched from contracts to acquisitions. The FAR Companion Guide says the FAR Rule of 2, which is 19.104-1, has been updated to use contracts instead of acquisition for greater clarity. This particular clarification aims to resolve a perceived conflict in interpretations between the Government Accountability Office, GAO, and the Court of Federal Claims around the application of the Rule of Two within the context of multiple award contracts. Oh, that doesn't give you the whole story, that sentence there. Really, the case is that there was a decision out of the Court of Federal Claims called Tolliver that came out in 2020 that said that the Rule of Two applies to orders. Orders are when agencies are issuing an award off of a multiple award IDIQ contract. The Government Accountability Office came out about a month and a half later. It's very quickly at the beginning of 2021 to say they do not follow that GAO. They do not follow that decision. Instead, they think the Rule of Two only applies at contracts. It does not apply to orders. So there's this conflict between GAO and the Court of Federal Claims on whether the Rule of Two applied when an agency uses a multiple award IDIQ contract. So now at first, the SBA and the FAR were going to change their regulations to adopt, in part, the court decision, the Tolliver decision. SBA came out with a proposed rule toward the end of 2024, and then the FAR followed with their proposed rule around the same time and got comment at the beginning of 2025. Now, the FAR has reversed its policy decision. Instead of following the Tolliver decision out of the court, the FAR is putting its thumb on the scales of the GAO decision, saying the Rule of Two does not apply when there is an order off of a multiple award IDIQ contract. Agencies still can set aside orders for small businesses or subcategories of small business like serviceable vet or hub zone, 8A or women owned, but they're not required to under the Rule of Two. That's the difference between what the Court of Federal Claims said in Tolliver and what the GAO has said, and now the FAR overhaul drafters have sided with the GAO decision. It's possible that this question still may come up in court before the Court of Federal Claims or another jurisdiction, but the FAR overhaul drafters have tried to set this up so that they are covered if this ever gets to court again. The reason that the Court of Federal Claims ruled that the Rule of Two applies to orders is at that time, the Rule of Two used the word acquisitions. And the Court of Federal Claims read the word acquisitions to apply to both contracts and orders. Now that the term has changed from acquisitions to contracts, that decision seems not to have as much influence or precedent on what the new FAR would say. There still is a possibility, though, that contracts could be read broadly. The Supreme Court had decided a decision, Kingdomware versus United States, back in 2016, that read contracts to include orders. So that may come up in a future decision and litigation. The FAR overhaul is trying to prevent that by saying that order level set-asides are not protestable. They would not be able to be heard by a GAO or by a court. I'm not sure that's going to work by saying that it's not protestable. Courts and bodies like to make those decisions on their own rather than having someone tell them whether or not they can hear a case. But at least the FAR overhaul has made clear in this companion guide that they were trying to address this particular conflict between GAO and the Court of Federal Claims, and they've looked at what they think is the right decision in GAO and said that the Rule of Two applies only to contracts rather than to acquisitions as a whole. The FAR Part 19 or FAR Companion Guide 19 also gives specific instructions for agencies to use when they would like to set aside orders under multiple award contracts. There's instructions for total small business set-asides, service-disabled vet. There's instructions for partial set-asides and instructions for federal supply schedules. So there's specific language that agencies can use when they would like to use a set-aside under a multiple award contract. That's all there in the FAR Companion Guide. And then one last element that I found fascinating in the FAR Companion Guide was instruction in there, or guidance. This is not a specific regulation that must be followed. It's guidance to agencies. And there was an element in there about subcontracting goals. Under the statute, the Small Business Act, subcontracting goals apply at the contract level. They don't necessarily have separate subcontracting goals at the order level, but at the contract level, agencies impose subcontracting goals through subcontracting plans. There is the ability through discretion for contracting officers to impose additional subcontracting goals for orders. So this might happen if the contract is, say, a government-wide contract, an agency that's not the original contracting agency would come in and issue an order, and they want different subcontracting goals because of some perhaps a negotiation with SBA, or because they're doing work that is distinct from what is contemplated in the government-wide contract. The FAR companion guide addresses this by saying that the ordering agency should, quote, leverage the master subcontracting plan and not require an order level subcontracting plan unless elements of the plan are considered unacceptable for the order level requirement. So the FAR companion guide is telling those ordering agencies that, yes, you may have the discretion to issue separate goals for the order, but we prefer you not do that. You should leverage the master plan instead of issuing additional goals at the order level. Why are they doing this? Is probably some concern about complexity for the contractor, for the agency itself. It does impact the way that agencies are going to make order awards, and probably does speed it up, but at the expense of creating new opportunities for small businesses at the subcontracting level. Now I'm going to turn to the Department of Transportation's FAQ. They, at the DOT, published what they called official FAQs for the DBE program. And this FAQ comes after the interim final rule that DOT published in the Federal Register on October 3rd, changing the DBE program so that DBEs now have to submit disadvantaged narratives in order to get into the program or to continue their DBE status. The FAQ answers a lot of questions that people had out of the interim final rule. One of the questions was, is there a deadline for existing DBEs to get their narratives into the state certifiers? Some states had put very quick deadlines on DBEs, 2 weeks in some cases, to get in their narratives. And there was inconsistency across the country on which states were requiring deadlines and which weren't. The FAQ says that there is not a specific deadline for companies to submit their narratives, but it should be as soon as practicable for companies to get their narratives in, so that the state should not be able to issue particular deadlines, but you have to get your narrative in so that the state can complete its reevaluation process, quote, as quickly as practicable. Another question was for DBEs that are certified in multiple states. Many of those companies were receiving notices from multiple certifying entities to get their narratives in, and so they might complete a narrative for multiple jurisdictions. The DOT FAQ addresses that scenario and says that only one of those states will be the lead state for reviewing the narrative. So that company that has multiple jurisdictions that is certified in is only going to have to submit its narrative to one state, and that state will be what they call the jurisdiction of original certification. So presumably that's the state that certified the company initially. That jurisdiction will have the lead on reviewing the DBE's narrative, and then if the DBE is recertified, then that DBE can then seek reciprocity from the other states that it is certified in. There were a couple of policy decisions that came out of this FAQ on where DOT might be able to potentially withhold payments from states, and additionally where DBEs might get terminated from their existing subcontracts. And this is very surprising to see in the FAQ. It seems like something that potentially would have come out of the interim final rule, but the point on withholding is in question B1 in the FAQ, which is at the top of page 2, and it says that if a DBE is performing work on a contract and is not recertified during the reevaluation process, the recipient, which is the state, will be required to take appropriate action to discontinue the effect of the unconstitutional certification. The FAQ goes on to state that if a recipient does not take appropriate action with respect to a contract DOT will not make any payments with respect to that contract. So that sentence gives DOT the authority to withhold payments from a state if the state does not take so-called appropriate action with respect to a contract. It's not clear what appropriate action is. It's not clear what they're referring to by an unconstitutional certification, but this FAQ puts states on notice that there are scenarios where DOT would withhold payments from a state because of a DBE not getting recertified during the reevaluation process, and then the state not taking so-called appropriate action with respect to that contract. There's also a provision that starts on the same page, goes on to page 3, about termination of DBEs on existing contracts. Now, it starts out by saying that a prime contractor cannot terminate a DBE without the recipient's prior written consent upon a showing of good cause. So it seems like during this process, you can't terminate a DBE because there's not good cause unless the state says it is. But the last part of that question says good cause for termination exists if a DBE loses its DBE certification after the reevaluation process is completed because it is ineligible to receive DBE credit for the type of work required. So this seems to suggest that termination could occur if the DBE that's on an existing project loses its DBE certification. So that puts now DBEs on notice that this is a give or die situation with getting your DBE narrative in, getting it approved, because if you don't, then good cause for termination could potentially exist under this FAQ. Also wanted to highlight a federal court decision that came out before I get to the FAQs. GAO is shut down, and the SBA OHA is shut down. So the court that I'm following the most now is the Court of Federal Claims, which publishes bid protest decisions. So there was an interesting case that came out a couple weeks ago involving the VA. The case is called MLB Transportation v. United States. In this case, the contractor tried to submit a claim against the government for a contract it already performed. It's a transportation contract, and they're claiming that there needed to be an equitable adjustment because of some changes that the VA had initiated in that contract. And the court made a really interesting decision. This is Judge Thompson Deeps for the Court of Federal Claims. The court said, let's not even look at the facts of the claim in this transportation contract. Instead, we're going to look at whether this contractor, which won a service-disabled veteran-owned set-aside, was qualified for that set-aside when it received the contract. That's all the way back in 2008, 2009. The contractor at the time was owned by a Baker, Mr. Baker, hence MB Transportation Company. And Baker was not a veteran. So the company came in and won a service-able veteran-owned small business contract with a non-veteran as the owner. This occurred because at that time, SBA did not have a certification program. The VA may have had a certification program, but perhaps there was some mix-up in how this company got the contract. And the company, after the contract, did try to reorganize and got the owner's brother-in-law to come in as a veteran owner, transfer the assets of the firm to the brother-in-law, and then the brother-in-law's firm is allegedly the one that carried out the contract. The judge said none of these facts about the brother-in-law and whether the brother-in-law took over the contract really matter, because the contract is void ab initio. That means the contract is void at the outset because the firm was not qualified at the time that it got the contract in 2009. Had the firm been qualified, maybe then you can look up the claim and whatnot. But here, because the firm was not service-able veteran-owned, and nobody was claiming that it was service-able veteran-owned when it won the contract in 2009, the firm can't look forward to any facts, and it can't try to submit a claim against the government. This void ab initio concept seems like it's only applied in the veteran-owned context. That's the only place that I see it. It actually used to be in the VA's rules before the rules came over to SBA. There's been other cases about the void ab initio concept for VA contracts. But as far as I can recall, this is the first time where it's actually been applied at the claim level, where a company has gone through a whole process, won the contract and performed on the contract, trying to submit a claim, and the court saying, actually, you can't do anything with this contract because the contract was void at the very outset. So this is important for companies with certifications to understand, because if there is in the facts of the case false certification and a clear false certification, you may not be entitled to anything under the contract because the contract would have been void at the very outset because of that false certification. So certainly something for companies to look out for as they plan their submissions on certifications. I did get a couple of questions in at GovCon Intelligence. Please keep your questions coming. You can find me on the website, govconintelligence.com. You can find me on LinkedIn, or you can go to my website, samleelaw.com, and submit something through the contact form. So there's a question about, can an agency prepare a set-aside that has more than one certification required? So say, for example, could you do an 8A set aside for only service disabled veteran-owned firms that also have an 8A certification? And the answer is, for the most part, no. You're not able to do that. The VA may have some special authority. I'm not really certain about that, but the SBA regulations say that you are not able to issue set-asides with more than one certification. And the idea behind that is that SBA wants to make the certifications valuable in their own right. They don't want to have, say, only firms with HubZone and 8A qualify for contracts. It has to be either a HubZone set-aside or an 8A set-aside, and not both. So under SBA regulations, you are not permitted to have set-asides with more than one certification. There's a question about the FAR Part 19 companion guide and whether it refers to OSDBU authorities and functions or small business specialists. Remember, from the FAR Part 19 overhaul, the FAR took out a really long section that went over the 21 or 22 responsibilities of OSDBUs, deleted that whole thing. At the time, I said, look, it's not such a big deal because it still appears in law. It's still in the Small Business Act. There's still a legal requirement for it. This FAR overhaul is speaking to contracting officers, and this really isn't relevant to contracting officers. Also, it might appear in the FAR Companion Guide. Well, it did not appear in the FAR Companion Guide. The FAR Companion Guide did not refer to OSDBUs or small business specialists. Is that surprising? I think it still doesn't release agencies from having OSDBUs or having these responsibilities for OSDBUs. They're still in the Small Business Act, actually appear in SBA's regulations as well. So the legal requirement is still there. The fact that it's not in the Companion Guide doesn't have any sort of legal effect, but it may have some sort of persuasive effect where agencies aren't including small business specialists because they don't necessarily see them in the Companion Guide or overhaul. We'll see how that works out. And then somebody asked also, with that change that I alluded to at the beginning, with changing from acquisition to contracts and the rule of two, how will that affect small business contractors? Well, I'll take the other end. Had it taken the SBA position where the rule of two applies to orders, what would have been the impact for small business contractors? SBA had calculated that would be an additional $6 billion going to small businesses because of these additional set-asides for contractors at the order level. So going from acquisition to contract instead of including orders is a lost opportunity of about $6 billion. $6 billion in the grand scheme of things. You have $600 billion in contracts every year. So that's less or more than 600 billion. So it's less than 1% of government contracting. So it's not a huge amount percentage wise, but it would add to the amount of contract dollars that small businesses are able to ascertain. Overall, for any specific small business contractor, it does create the opportunity for an agency to circumvent small business protections by going to a vehicle with large businesses or perhaps only large businesses so that they don't have to necessarily use a small business. I hope that won't happen. I hope the small businesses will continue to get prioritized under these vehicles, and agencies have the opportunity to go to many vehicles that are already set aside for small businesses, or have an 8A pool or a small business pool that they can use. And agencies should take up the opportunity to do so that small businesses still get a fair share of government contracting. We'll certainly be watching this very closely to see what the impact of this change of the rule of two is. And there already have been congressional proposals to expand the rule of two orders. And if the small business share of contracting drops, then you might expect for those proposals to move forward. Okay, please keep your questions coming, govconintelligence.com. Thanks very much, everybody. Talk to you again soon.